Hello, folks. This is Chris DiOrio again, here for ChrisChat number 2. Thank you, all of you who stopped in last week for the initial ChrisChat. That was rather humbling to watch people actually log in. Pretty cool. But what I wanted to talk about this week is questions related to post-election issues regarding the law and legal issues addressing the LGBTQ community, as well as women. I've seen a lot of news reports, etc., with folks chiming in about what they believe will happen, but what's most important here, and what I really want to get you folks away from, if possible, is to just sort of answer basic questions, if possible, about what is likely to happen. There's a lot of misinformation out there on both sides of the political spectrum, all sides of the political spectrum. So I want to make sure that folks out there have a general understanding as to what could happen, what is likely to happen, what is unlikely to happen, and just a better understanding of the process. Because some people believe that it's going to be an immediate change, but that's not necessarily the case. And I think that's sort of beating the drum a bit too loudly. So I want to step in here, and first, I want to break it down into 3 parts. First, what you should or shouldn't be worried about would be the first thing. The second thing is what you definitely should take care of, things that you should be looking for, and third, what you can do, because there are certain things that people in the LGBTQ community need to do, or at least take care of, in order to protect their rights if things happen. So first I want to get directly into questions related to the 2 big cases out there that folks have asked me about. What about the continuation of same-sex marriages? And what about Roe versus Wade? What will the election do now that we have a Republican president and a Republican-held Congress in both the House of Representatives and the Senate? What will happen? What could happen? First, in terms of Obergefell and Roe and things of that nature, the first thing you have to be aware of is courts, at least at the federal level, don't like reversing themselves. They just don't. It is rare and an extreme case when courts will out and out reverse themselves, much less reversing themselves within 2 or 3 years of an initial decision, a groundbreaking decision. Granted, Roe took place in the 70s, and we're now 40 years sub Roe's occasion, but courts don't like reversing themselves. It really takes something special or overt for a court to change their minds. And as far as the reversal of the same-sex marriage decision, what you have to be aware of is it requires what's called a case in controversy. There has to be an actual case before the Supreme Court in order for it to happen. So the Supreme Court can't just decide on their own that we're going to get rid of same-sex marriage. They can't just decide on their own to change the law regarding a woman's access or right to an abortion. So these things take time as far as the court is concerned. What also you have to be aware of here, I think, in relation to, and just talking in general about the process, it's not this one seat on the Supreme Court that people have made into a large issue. And it is, in fact, an important seat. But in terms of control, in terms of what can happen on the Supreme Court, first be aware of this. The United States has had, for the most part, a conservative-leaning Supreme Court since at least 1980. We have had 5 or more Republican or Republican-nominated justices on the Supreme Court since 1980. This is not a new thing where we have, folks stepping in and saying, "Oh, the court is, going to go conservative." It's been almost 40 years, and yet we still have decisions that, like Obergefell, like, Windsor, like Planned Parenthood versus Casey addressing abortion rights. We do have cases that come down, for want of a better term, on the right side of history. So this one seat was held by Judge Scalia, who passed away in February of this past year, and it's been held open. And the court has been balanced for at least the last 14 years, with 4 justices sitting on the right, 4 justices sitting on the left, and Justice Anthony Kennedy, who was a Bush nominee, Bush the first nominee, sitting right in the middle as a moderating force. And he swings conservative on some issues, but Justice Kennedy was the author of the Windsor decision that struck down DOMA. Justice Kennedy was the author of the Obergefell decision that legalized same-sex marriage throughout the United States. So we have a balance, and this empty seat will be filled by a, for want of a better term, conservative president, a Republican president who's been elected and now has a Republican-controlled Senate to advise and consent and affirm his nominee, whoever it is. So putting that nominee in that chair simply restores a balance that already existed. The 4 on the right, the 4 on the left, and the 1 in the middle. The concern is not this one seat that's open. The concern is twofold. First, the number of justices that are in their early 80s that could retire, 2 of them on the left side of the spectrum, Justice Ginsburg and Justice Breyer, who's 78, Justice Ginsburg is 83, and Justice Kennedy, that middle moderate conservative that has been riding herd over justice for the past 20-some years, is also 80 years old. Those are the seats that you should be worried about, because if those seats get filled at some point down the road, then you have a potential imbalance. Even more important, though, when it comes to these hot button issues for both the LGBTQ community and for women, the issue is not the Supreme Court and filling those seats. The issue is the other courts. Right now, the federal system has 101 open seats for federal judges at both the district court and appeals court levels. Those are empty seats that will now get filled by a conservative-leaning president and legislature. There are 19 more seats that are going to open up by September of 2017 for retirements and things of that nature, judges becoming emeritus judges. So that's almost 120 federal seats all throughout the country that are going to be reopened or open now that will be filled. And that's where cases are going to be decided, at the lower court levels. Above and beyond that, 30 of the 50 states are controlled by Republican legislatures, and 31 of the 50 states are controlled by a governor who is a Republican. And Republican governors get to pick the judges, except in states where judges are elected. But Republican governors appoint Republican judges. So that's where the issue lies, not necessarily here in the Supreme Court with that one seat, but in all of these hundreds of other seats that get influenced at lower levels. That's where initial cases come. So when we're talking about a case in controversy, that's really what we're looking at. We're looking at these lower courts that where actions are brought against discriminatory actions that will rise through the appellate procedure. And if the Supreme Court decides not to hear a particular case, then the decisions from the lower courts stand. So when the case gets appealed all the way to the Supreme Court, and the Supreme Court says we're not going to grant it a hearing, then whatever was said at the last level, that is the law. So while the Supreme Court justice in that one seat is important, and the future seats are also important, what's especially important is the fact that there are 100-some seats in the federal system that can be filled right now, very quickly, by a conservative-leaning Senate That's where the issue comes. And that's for future reasons why we need to look at those levels and why Senate elections are important and why local elections are important in terms of selecting governors, etc. There is no, however, in directing specifically to these issues, right now, there is not any case in the federal system that addresses same-sex marriage. So there is not an instant case that's a problem. There could be. There is not a single case or a single present statute waiting in Congress that will have an immediate impact on the right to marry. But there are issues related to whether these laws are coming. Less at a federal level, more at an individual state level. You need to worry about those things. And I want to address at the end, like I said, the things to do, what you can do if there are issues that you need to address as an LGBTQ person. Just a general primer about why the Supreme Court is unlikely to address Obergefell directly, why they're unlikely to address Casey and Roe. And when I refer to abortion rights, I refer to both Casey and Roe. Obergefell stated pretty straight out that we have a 5th and 14th Amendment right to marry, that right to marry is covered by both the Equal Protection Clause of the 14th Amendment and the Due Process Clause. Roe stated very specifically that the right to privacy, which had been well settled 10 years before in the case of Griswold versus Connecticut, the right to privacy includes the right to abortion and the right for a woman to choose what to do with a fetus up to a certain point. Justice Blackmun constructed the trimester system at that point, which became untenable and for all purposes now is relatively untenable. But the more important case is not Roe necessarily. The more important case is Casey, which came down in 1992, which created what is now known as the undue burden standard. The question now is not whether you have a right to an abortion. The question is whether a state can impose laws that create something that is known as a substantial obstacle to a woman's right to terminate a non-viable pregnancy. That's really the standard. It's not Roe. Roe established something that exists already, the right to privacy and the extension of that right to women and their ability to make a choice as far as terminating a pregnancy. The real test, the one that we keep fumbling with for the past 24 years, is whether something is an undue burden, whether it's a substantial obstacle for women. That is going to require state laws. It's not going to be a federal law. State law is what you have to worry about here. It is, again, unlikely that they're going to attack Roe directly. And one of the reasons why is folks who are in regarding the abortion rights fight on the right side of things, as far as conservatives are concerned, the anti-abortion folks, they know how to play the long game. They will wait, not for this one justice, but they'll wait to see if they can get 2 or 3 more justices. So it's unlikely that they're going to attack it directly in the federal courts now. Where they will attack these rights, potentially, is, and where they're much more likely to do, and as they have been attempting for the past 20-odd years, is with what are known as TRAP laws, T-R-A-P laws. They're targeted regulations of abortion providers, T-R-A-P. The most recent was down in Texas, where they tried to impose certain regulations on abortion providers, abortion clinics, etc., to require that they have surgical status at local hospitals, to require that they have the same surgical equipment and facilities as any hospital that had surgical rights. And the Supreme Court said in a divided decision that this was, in fact, an undue burden. But what they've also done now, and what folks need to be aware of, is the undue burden test now has an additional layer on top of it. If any of you who know what accounting, basic accounting and things of that nature, the cost-benefit analysis is what they look at. They're now going to look at undue burden as to whether the law that is being imposed or attempting to be imposed, they will have to show, whoever is progressing with this law, will have to show actual health benefits to the law that is greater than the undue burden posed against the woman. And if you look at these laws that are being proposed, most, if not all of them, do not necessarily have general health benefits. Notice clauses, delay clauses. Some of the laws that passed in Indiana under Governor Mike Pence, now Vice President-elect Pence, requiring a woman before undergoing an abortion procedure to listen to a Doppler of the fetal heartbeat prior to making a final decision to go ahead. The requirements about burying the fetus or paying for the burial of a fetus. These are laws that impose burdens that do not exceed, that don't have actual health benefits. They're more designed to impede the progress of a woman who's proceeding to attempt to exercise her choice regarding a pregnancy. So those types of laws are unlikely to pass. But in terms of a woman's right to choose and Roe, again, the idea here for most of these groups is that you wait. It's not this first justice that's going to be the problem. As I said, this simply reestablishes the existing balance. Groups that are going to proceed against Roe and against a woman's right to choose are more likely to wait and see if this president will be able to put more lower court federal judges on the bench, but to get 2 or 3 seats filled on the Supreme Court, not just this one, because there is a very tenuous balance that has existed on the court for, as I said, the better part of almost 40 years. So there's a lot of back and forth as far as this one seat being so important. It is, but not as important as the ones that are not yet empty, but may become empty very soon. So in terms of Roe, and in terms of Obergefell, there's nothing really out there right now that addresses these matters. What you need to be aware of is looking more at local laws, state laws that are being imposed, tracking those and examining those, because there isn't anything out there yet. Could there be? Is there something that you should be worried about? Yes. If local states feel like they want to do things to discriminate, then you have to address those. But not something at the federal level, at least not yet. Should you keep your eye on it? Absolutely. But as for Obergefell and Roe and Casey, there's nothing in the pipeline right now that addresses that. So I would urge people to do a little pumping of the brakes as far as those areas are concerned. Do you still need to be concerned? Yes. Do you need to be vigilant? Yes. But right now, in terms of actual change in the courts, not yet. That is not the case, however. And I wish I had better news, but that is not the case for transgender individuals. That is an entirely different story. Because there are, in fact, cases right now in the pipeline, and 1 or 2 very important ones that are sitting in the Supreme Court, one that has been docketed and one that very well soon may be docketed, regarding the rights of transgender individuals and transsexual individuals. This president has already stated, both post and pre-election, his intention to rescind any of the executive orders signed by President Obama, as well as any administrative agency decisions that are being addressed related to the rights of transgender individuals, both at schools and in the workplace. President Obama had, through his administrative agencies, had looked at both Title VII of the Civil Rights Act, which relates to employment issues, and both Title IX relating to educational issues. And both of those agencies, both the employment, Department of Employment and the Department of Education, both of them had agency determinations through the executive order that applied gender identity, that any restrictions related to sexual discrimination regarding sex discrimination also applied to a person's gender identity and not just their born gender, for want of a better term. The challenge then came with multiple lawsuits addressing what many state legislatures and local schools and employers looked at as being a question of overreach regarding these regulations. One in particular has been docketed right now in the United States Supreme Court. It has not yet been scheduled for hearing, and that's something that we'll talk about. You have likely heard, if you have not already heard, of the case of Gavin Grimm regarding his school in Virginia and access to a bathroom that fits his gender identity and not his born gender or sex. That case has been docketed to be heard, but it has not yet been assigned for any hearing date. It is unlikely that this court will be able to hear it and have 9 justices on the bench. The approval process for vetting a justice is long and arduous and might be much quicker based on the current composition of both the Senate and the occupant, or soon to be occupant of the White House. But it does take time, and it is unlikely that the case will get on the calendar for hearing in time for a 9th justice to be sitting to hear the case. So it is very likely that this case will be heard by a court comprised of 8. More importantly, however, though, is not necessarily that the case will be heard in front of 8 or 9, but what affects this directly is if the president, as he said that he would, rescinds the executive orders from the White House, from the Obama administration, that had the Department of Education and the Department of Health and Human Services look at these gender identity additions. If he rescinds those, now what happens is once these orders are rescinded, it messes with the case that's there. The original Supreme Court case was brought with the understanding that these additions, these extensions of discrimination protections to gender identity would still be there. If those protections no longer exist, it could result in the case being removed from the docket. It could result in the case being heard, but the justices then saying, well, this is an unclear question and we want to send it back down to the states, which then extends the time and it may never make its way back up to be heard by the Supreme Court. So we don't know. So the Grimm case is directly affected by this. What I want to make clear, though, in relation to the Gavin Grimm case, the case is not about whether it's allowable for a transgendered person to use a bathroom that matches their gender identity as opposed to their born gender. That's not what it's about. The case is very technical. The case is more about whether the president or the administrative agencies that relate to this have the legal authority to tell lower schools that they have to do this. It's not a direct answer to the question of can a person use a particular facility. It's not going to address HB2 in North Carolina. It's not going to do that. What this is more of a technical test of whether these types of changes in administrative policy are allowable and whether lower state school boards have to abide by them, or whether they're an overreach. And that's really the question that's being decided. So yes, it will affect transgender rights, but it will not be a direct statement from the Supreme Court that this is allowed. It's not going to be an Obergefell kind of decision that says we're denying this right now and we're saying that the 5th and 14th Amendment, equal protection and due process clauses all apply. That's not what Grimm will do. What it will do is talk about the authority of executive orders and administrative agencies to tell states what they can do. So it's rather dry. It's more for court nerds like me to address. But that's really what the question is going to be. However, Grimm is not the only case that's out there regarding transgender rights. And many of the suits right now relate directly to the authority of the Affordable Care Act, otherwise known as Obamacare, to tell states and employers and schools what they have to do regarding gender identity. There is a current suit right now wending its way through the federal courts that addresses Section 1557 of the Affordable Care Act, which, again, similar to what we have in Grimm, was an extension of non-discrimination protections to gender-identified people. As a result of that provision in the Affordable Care Act, in essence, saying that gender identity is something that has to be protected, 20 different states, through their legislatures and through their governors, as well as 3 religious organizations and a number of religious institutions, colleges, etc., have brought suit against the federal government related to these, specifically 1557 in Obamacare, saying that this is an unconstitutional or illegal overreach by saying that we're changing the definition of sex for purposes of discrimination by saying gender identity also classifies. This is another almost religious-based challenge to the Affordable Care Act. And if you look at the former composition of the court and the potential current composition of the court, these types of challenges have already succeeded. The Hobby Lobby decision was a 5-4 decision that came down on party lines, for want of a better term, saying that the corporation had religious freedom rights, and therefore it restricted what the ACA could do as far as ordering these people to provide contraception for their employees that contradicted their rights to religious belief and religious freedom. If, in fact, there are issues related to gender identity that are conflicting with certain beliefs, then it is a complete possibility that this provision will also fail. This case is in the federal system now. It likely will not get to the Supreme Court this term. But if this president puts a justice in that seat this term, as he likely will, before the year is out, and if other seats open up, as I said at the beginning, if that balance is affected, then this case might make its way to the Supreme Court in time for a court that is not balanced to address it. And so in terms of transgender rights, that is definitely an issue that needs to be addressed. I have a question here. Is the executive overreach here a breach of enumerated powers given to the states? That's the argument that's going to be heard. And so is it? I can give you arguments for and against. The question is, what can a president or an executive agency do? If there are powers given to the states, if there's a 10th Amendment violation, then so be it. It's a question of what the federal government deems to be an area that they've already stepped in. The rules regarding the 9th and 10th Amendment usually say that if the state is involved, then if the federal government steps in, if it's something that's labeled as part of their enumerated powers, then the states can't supersede that. They can add to it. They can give more protection. They just can't give any less. But in terms of whether an executive agency can do that, that's within their purview. So yes, this is a potential challenge. And it is something that bears watching out for in terms of transgender rights. So if you have any questions specifically related to Roe, to Obergefell, and the likelihood of things being changed there, by all means, chime in. In terms of, so I've talked about what you need to be not worried about in terms of the immediate changes related to same-sex marriage, related to abortion rights, et cetera, as far as the immediate changes. That's not something that you have to worry about happen immediately, at least at the federal level. Locally, you do need to be worried about certain things, because now there is the possibility that lower courts will address these matters. There is a possibility that state courts will address these matters. And that's where you really need to be focusing your attention at this point now. Local legislation and federal legislation, because there isn't anything right now in the federal pipeline to worry about. But in terms of transgender rights, that is something that needs to be addressed. What can you do, or should you be doing, to protect yourself in terms of whether you are a transgendered individual, whether you are a member of the LGBTQ community, about your rights going forward? First, if you are a transgendered person, one thing that you need to do is address your identity legally. Each individual state has their own regulations regarding whether you can change your identity on a birth certificate or on your driver's license. You have to address these things by state laws. There is a website out there that I would direct you to. It's called transequality.org, and they have a listing of state requirements regarding what individual state laws attach to your ability to change your identity stated on an ID, what's necessary as far as a passport is concerned, birth certificates, driver's licenses, etc. Go there. Massachusetts does not have specific rules regarding your initial application, but if you change in the future, you do have to have some sort of, you have to fill out an affidavit in many states now, and Massachusetts is lining up there as well. Requires some sort of affidavit regarding an actual change. We're not as good as we should be in terms of changing a gender identity on an ID. Many states require that there be some physician affidavit that's filled out that will say that this person has actually changed their identity from male to female or from female to male, an actual physical change required. Some states do not. Go to this website, transequality.org, and check out your state, wherever you are, to determine what it is that you need to do. Secondly, for folks who are in same-sex couples or same-sex relationships, whether you are married or not, and you have children, or you are planning to adopt or have children by means of artificial insemination or some other type of thing through donors, you need to be aware of your rights regarding second parent adoptions or joint adoptions if one of the parties is not bearing a child. By law in Massachusetts, a child born of a married relationship, regardless of whether it is a same-sex or the quote-unquote traditional marriage relationship, you have to have a child born of that relationship is considered a child of that marriage. So you're protected in Massachusetts, and you wouldn't necessarily need in Massachusetts to have, a certificate of adoption. But what if you leave Massachusetts? What if you go to another state where these laws aren't the same? They could deny you access to your child. They could deny you the ability to take your child into a hospital, to get medical care, for educational purposes. I strongly urge folks who are involved in same-sex couples or looking to adopt or to have children within their marriage, I strongly urge you to engage in a second parent adoption in a marriage or in a relationship, or have a joint adoption, because once you do that here in Massachusetts and anywhere where you're allowed to do these types of adoptions, once you do that, you are in fact a legal parent of that child. It cannot be your rights cannot be taken away from you at that point, regardless of your sexual orientation, you are that child's parent for purposes of school, for purposes of medical care, for purposes of access to hospitals, access to records. You are a parent. So while you have that right in Massachusetts to have a child born of a marriage, if in fact that's your situation, and that child is your child legally at that point, it's not the same in the other 49 states. You should have a second parent adoption in place. If you are adopting a child, and if it's two men who are adopting a child, have a joint adoption procedure there. Even if it's a woman and another woman, and one of the women is not bearing the child, you have to have some sort of joint adoption procedure, because while the laws in Massachusetts allow this, other states do not. And so once you have that adoption in place, you are on the child's birth certificate, you are the parent. So I strongly, strongly urge folks who are same-sex couples, married or not, if you are engaging in child rearing or childbearing or seeking to adopt a child, be sure that you can't, and don't do it on your own. Contact a legal professional who knows what they're doing as far as joint adoptions or same-sex adoptions. There are things that the forms that you need to fill out. You have to fill out the joint petition. There are affidavits. There are CORI forms. You have to notify the Federal Registry of Missing Children, just in case this child that you're adopting, if it's not born to one of you, is not on a missing child's registry. It's easier to do when it's a same-sex couple at times, because you can waive a lot of the hurdles and roadblocks that stand in the way of most other couples having an adoption. I strongly urge that if you are in that classification, that you go immediately, if not sooner, and get your rights recognized in a court by means of a same-sex or second parent adoption or a joint adoption procedure, because then your rights are locked in. I've had a question recently in my practice about something called a de facto parent. That is something that's allowed in Massachusetts and some other states. Basically, even if you're not adopted, if you can show that you have constant contact and live in the home, etc., you can be considered a de facto parent and then have some degree of rights. But again, once you cross a border and go into another state, it's that much more difficult. It's that much easier for you to go about the process of going through a same-sex adoption. It takes less than 6 months if you're using a legal professional and they're doing it right. Do it that way. Third, extremely important as well, there are regulations and executive orders proffered by the Obama administration related to individuals having access to their partners while they're in hospital, while they are being treated. And those regulations say that a patient has the right to choose who has access to them. But that is one of those executive orders that is potentially on the list to be rescinded by the new administration when it comes in, and certainly allowable. It would violate most state laws. It very likely would address these problems. But if he pulls these things out, or if the legislature decides to rescind them on their own, what do you do about having your partner having access to you, not being excluded from discussions regarding treatment, not being excluded regarding access to health care? There are certain things that every couple should engage in, regardless of whether it's a same-sex or other marriage, but especially in regard to your rights as a same-sex couple. First, look into a cohabitation agreement. If you don't want to pull the trigger on a marriage, but you still want to be able to have the ability to have access to certain rights, look into a cohabitation agreement. They're allowed here in Massachusetts. Get on board with that. Execute a power of attorney. Find a legal professional I'm going to keep saying find a legal professional. There are plenty of websites out there that can help you do this, and you pay them, and these things don't work. They're looked at and they're laughed at. Have an actual attorney help you out. It's worth it. A power of attorney that gives you agency authority over the day-to-day effects and requirements and business of a person who may not be able to do things for themselves. It's simple. It's 2 or 3 pages. It's really easy to do, and it's terribly inexpensive. Go do that. Get a healthcare proxy. which has living will provisions inside it. A healthcare proxy is acknowledged as being your right to select who it is that's going to speak for you. And there are default provisions to family members and immediate family. If you don't want that, if you want your partner involved in those decisions so that they're not excluded from a hospital, so that they're not excluded from decision making, so that they're not pushed aside, in some cases being asked to leave the hospital entirely and restricted from having any access at all. If you don't want that, get yourself a power of attorney and a healthcare proxy that addresses these issues. Have a will in place that grants executor authority or personal representative authority to your partner. If you don't have a will in place, the provisions usually regarding what's called intestacy is they go directly down through family members. And if you're not a spouse, you're out. If you're not acknowledged, you're out. So have a will in place with a healthcare proxy and a power of attorney. Also, for those of you who are engaged in same-sex relationships that have children, select a guardian. If you're not willing to go through the process of a second parent adoption or a joint adoption, and I don't know why you wouldn't, but if that's not something that you want to engage in or be involved in, have a guardianship in place where if something happens to you or the other parent, that you name each other as the guardian of that child. Again, the idea here is to not just protect yourself in Massachusetts, where many of you are, but also to have something in place in writing where you can have legal rights to your child regarding healthcare, regarding addressing teachers, regarding access to medical records, regarding access to education records. These are terribly important. These are things that you need to take care of. These are things that you need to address. So I have reached the end of my time. If there's any questions out there, I'll be happy to entertain them. If you have any suggestions for future chats, I'm looking potentially at having a couple in the future related to religious freedom questions. There are a lot of issues regarding, or a lot of questions and fears on both sides regarding the so-called Muslim registry that is being offered potentially. If that's something that can be addressed in terms of the First Amendment, is that something that we can permit or not permit, and how First Amendment rights can be set aside in regards to national security potentially, or so I want to get into that. That's definitely on the docket for the future. But if you have any further questions related to those issues, or if you have any other further suggestions regarding chats that you'd like me to engage in and questions you'd like me to answer, by all means. Otherwise, if you have, I'll leave it here open for a couple of questions if you have them. But in terms of today, that's what I wanted to get into. It's conceivable, in relation to, I'll step back a little bit. If you get enough Supreme Court appointments on the bench, that Roe and Casey are in trouble. But again, the greater fear is not the 9 at the top of the pyramid. The greater fear is the long-term effect of having over 120 judges, and potentially more after 2017 even, having the judiciary of the federal bench being affected by one particular political party. It has not happened in a terribly long time where there has been control by one party for so long. And while I've said it multiple times before, and I'll repeat it again, the power of the president in Article 2, read it by all means. Being the commander-in-chief of the United States military is terribly, terribly important. In fact, probably the most important job that a president has, at least the job that's been given to him constitutionally. But more important in terms of legacy is the president's power to select, with the advice and consent of the Senate, members of the Supreme Court and members of lower, what in the Constitution is referred to as inferior courts. A president sits in the Oval Office for 4 years, possibly 8 years at a maximum. But appointing young, late 40, early 50-ish judges to the federal bench, whether it is a U.S. District Court in Massachusetts or Idaho, or whether it's one of the 9 seats at the top of the pyramid, as I said. Those are lifetime appointments, and they will be there long, long after the president that appointed them is there. Justice Kennedy is sitting on the bench right now. He was appointed by George H.W. Bush, George the First. He's been there since then, in the late 80s, early 90s, going on 30 years on the bench. He was appointed young. Justice Kagan and Justice Sotomayor are young justices. They were appointed in their 50s. They will be there, hopefully, assuming good health, that they will be there until their late 70s or 80s, just like Justice Ginsburg. If you appoint young justices, then you have affected the law for decades, and it would require a complete overhaul to change that direction. That's where you should be worried, not about that one empty seat. Be worried about the hundreds of others that will come up during the course of the next 4 or 8 years. Those are the areas where you need to be looking, and that is why lower elections are important. As I also suggested, local state governors are allowed to select justices. That's the way it is here in Massachusetts. So don't sleep on local elections. Don't sleep on your congressman. Don't sleep on your Senate election when it comes up, because those people sitting in those seats affect the judiciary. So address those things. So hopefully this time together has been informative. I will post this for people to review and to watch at their leisure. If there are other questions that come up after the fact, by all means, please add them, and I can talk to them offline and address them if I can. But otherwise, thank you again for stopping in for a little Chris Chat.